We're going to think a lot about how corporate actions do and do not afford protection for creditors. This topic is intimately related to limited liability, obviously. Limited liability can lead the corporation to generate a very particular kind of externality. Thanks to limited liability, the costs of a corporation's activities might induce it to externalize risk onto creditors, both voluntary and involuntary. And in the eyes of many people, the chief problem with the corporation and limited liability is the externality onto involuntary creditors. By voluntary, we mean people who choose to become a creditor of the corporation, generally people who enter into contracts with the corporation. And by involuntary creditor, we mean people who become a creditor of the corporation without any choice in the matter, people who are harmed by torts of the corporation. Easterbrook and Fischel make the point that all contractual creditors will anticipate this effect and protect themselves in the form of, say, a higher interest rate. I know I won't be able to recover from the owners of this entity, so to compensate me for the risk, I'm going to charge a higher rate. In this way, the corporation itself and the stockholders who benefit from the limited liability bear the cost of that limited liability when they take on debt. And in this way, creditor protections are principally contractual and not corporate. These contractual features, which we're not really going to think about, are often forward-looking. Firms that are borrowing money will make promises in borrowing agreements that restrict their ability to take the money out based on some financial ratio, or afford protection in some other way to the lender, like giving the lender a security interest. Involuntary creditors are in a different predicament because they don't have the opportunity to adjust the terms on which they interact with the firm. They just sort of get harmed in some tort. Corporate law everywhere provides baseline default protections to creditors. And the most natural explanation for the existence of these systems is that limited liability makes creditors in some circumstances vulnerable to opportunism by the corporation or its stockholders. And the book introduces three broad genres of legal protection: disclosure requirements, regulations of corporate capital, and then ex post judicial review. These are the three types of protections we'll examine. This video is briefly going to think about the first two of those types of protections. To really overgeneralize here, you can divide all of this into two categories. The first type of protection places some restriction on distributions that are generally forward-looking. These would have the effect of stopping the distribution before it happens. You can't distribute money unless XYZ, right? That's some kind of capital regulation. The second type involves a backward-looking analysis to see whether some director, stockholder, creditor should be made liable for corporate debts based on what's already happened. These would have the effect of undoing the distribution after the fact, so ex post, or maybe imposing damages on somebody after the fact. But like I said in this video, we're thinking about mandatory disclosure and capital regulation. Mandatory disclosure generally doesn't prevail in the US. Corporations do not have to make any kind of disclosures for the benefit of creditors. Sometimes there are disclosures that are required to be delivered to stockholders, but creditors don't get them. And public companies must file with the SEC, we'll talk about that. The result, those are public, is that creditors and anyone else can see that information, but that's a small universe of corporations, although that is a regime that benefits stockholders principally, but also provides an incidental benefit to creditors. This second category, capital regulation, These are legal provisions that constrain board discretion to distribute value to stockholders out of the corporation, to send cash out, to send assets out. US law very weakly constrains corporate distributions. They exist, but they don't do a lot. Many other jurisdictions have minimum capital requirements or capital maintenance requirements that have more teeth. Let's talk about distribution constraints first. Corporate creditors really could not sleep very easily at night without at least some limit on the board's discretion to distribute assets out of the corporate shell to stockholders personally. Limits like that are a small but an essential form of capital regulation. Statutory corporate law in the US has two kinds of these distribution constraints: balance sheet tests and equity and solvency tests. Balance sheet tests focus on the assets compared to the liabilities. These are, in some ways, the less meaningful of the two tests, but they introduce the mysteries of how stockholder accounts work on the corporation's balance sheet. Traditionally, these kinds of balance sheet tests require that stockholder distributions be paid out of one or both of the two surplus accounts, meaning capital surplus or retained earnings. You can see this here. This is why these are called balance sheet tests, because we're thinking about the distributions as growing out of particular accounts on the balance sheet. You have the assets and the liabilities. Remember, the difference is, in a sense, what's left over, what the stockholders own. And you can break down that stockholder equity further into stated capital, capital surplus, or retained earnings. The traditional balance sheet test says that money paid to stockholders can only come out of retained earnings or capital surplus. This third account, the corporation's legal capital or stated capital, is unavailable for a distribution. That was, once upon a time, a trust fund reserved for the corporation's creditors. Some jurisdictions might still think of it that way. But in the US, legal capital at this point is extremely low. These are small numbers, like 1% or less of the issue price of common stock. Not only is the amount low, but a board, under many circumstances, can make distributions that have the effect of impairing the value of stated capital. As the text of the book explains, a Delaware Board of Directors can shift value from stated capital to the capital surplus account at its discretion. Delaware, New York, and other states allow what are called nimble dividends, distributions made out of net profits when there's not enough capital surplus. And finally, a board can revalue assets carried at book value to reflect their current market value. That can have the effect of freeing up assets for distribution. We'll work through some of this with the Alpha Incorporated questions in the book. The other two things in this category, minimum capital and capital maintenance rules, I want to mention just for a second. They're not a big deal in the US, but foreign jurisdictions rely on them. They're worth noting simply to drive home the difficulty of using the balance sheet as a form of creditor protection. Capital maintenance requirements are more ambitious than minimum capital rules. They aspire to ensure that a company retains its legal capital over the course of its operations. Such regulations could require a corporation whose legal capital is impaired by a reversal to announce this fact to its stockholders and maybe even to its creditors. And if the finances deteriorate further, the law may force a stockholder vote on its dissolution. Again, this is something you can imagine. It's in the US. It doesn't prevail in the US, but it does in other jurisdictions. Um, but again, the US has never really adopted something like that.